Hello and welcome to the Ken Vercammen Law of Legal podcast. This edition, we look at trying to probate a photocopy of the will, not the original. When an executor seeks to be named under the will, they simply need to bring the original will with original signatures to the county surrogate, together with a death certificate and check for about $150. However, what happens if the original will can't be located? Under such circumstances, often the surrogate cannot act. Let's say, so there would have to be an attempt to ask a superior court judge to omit the photocopy of the will. So in general, if the original will cannot be located, and all beneficiaries, all potential heirs agree to the copy, it makes things easier. However, should one person not cooperate or challenge, then it becomes much more complicated. There's a presumption where the original can't be located that the original was destroyed and therefore revoked. Once revoked, then either a prior will could be omitted, or it's in a state without a will. So to file an action to emit a photocopy of the will, the party must rebut the presumption that the original was not destroyed and revoked by clear and convincing evidence. This is a difficult burden to sustain, as the evidence must clearly and convincingly demonstrate that the original was not destroyed, but instead was lost, and the court is justified in probating a copy of the will. A notice must be served upon any person in the world that would inherit if there's no will. Any person who opposes probate of the will may seek to present proof that the will was in fact revoked. Such a hearing has to take place before a superior court judge, as in all contested matters. So there has to be a complaint or to show cause served upon everyone. During the evidentiary hearing, the court will have to determine whether the copy of the will should be admitted to probate and whether or not the plaintiff has met their burden. If it's not met the burden, then their decedent is deemed to have died without a will, and then someone would have to attempt to qualify to become the administrator of the will. For more information on probate and where there's no original will, visit website njlaws.com. And for representation, contact Ken Vercammen's office in Edison at 732-572-0500. Thank you.